I'm just going to talk about one bill and then a policy package. I do want to say first that in the discussion about vacating TPRs 419B 923, and because this is being recorded, so I don't want to be wrong on the tape. Actually, it says that you can't modify or set aside a TPR judgment after a child's been, after an adoption proceeding has been initiated or an adoption petition has been granted. So it's not placement that cuts off the modification opportunity. So I want to be clear about that, and correct that. And that, again, for everybody here and out there in tape land, is 419B 923. So I want to talk briefly about House Bill 2181. You've heard a lot about changes in terms of contents of reports, and that's what this one is about. This bill modifies 419B 440, which is the statute that requires DHS to provide regular reports to the courts and the other parties. So as currently written, this statute requires a report to the court and the parties anytime a child's placement changes, either immediately before or as soon as practicable after that placement changes. Okay? That's already in statute. You ought to be doing that. It also requires a report after the child's been in the custody of the agency for 6 consecutive months, and then every 6 months thereafter. That's the 333, the 6-month reports, okay? And then it also requires a report currently if the child's been surrendered for adoption or the parent's rights have been terminated and the agency hasn't physically placed the ward for adoption or adoption proceedings have not been initiated. What does that sound like? It sounds like the bill we just talked about. That report likely will trigger then that permanency hearing that's required 6 months after the relinquishment or the termination. Do you see how that fits together? The new reporting requirement is that DHS must send a report to the court if the child has been returned home but remains in DHS's legal custody for 6 months. So if you have a case where a child goes home, either you should have sent a report to the court before that happened or immediately after that happened, so that would be the first report. Then 6 months after that, you have to send another report, and every 6 months thereafter, so long as the child remains physically with the parent, but in DHS's legal custody. Okay? The report has to include, in addition to all the other information already required, it must include a recommended timetable for dismissal of DHS's legal custody and termination of the wardship, as well as a description of the services that the department will provide or has provided to the parent and the child. Okay? And then the court is required, within 30 days after that 6-month report, to hold a hearing on that child. Now, what the court is going to have to, it'll be a review hearing, then the court will have to make specific findings about why is necessary and in the best interest of the child to remain in the legal custody of DHS despite the child being in the physical custody of the parents, and set an expected timetable for dismissal of the DHS's custody and termination of the wardship. This is really focused on trying to keep some attention on those cases where kids go home but they still are in the legal custody of DHS, and trying to get DHS backed out of those cases as soon as it's appropriate to do so. Even if DHS's legal custody is dismissed, DHS, as I understand through Mickey, can continue to provide services to the family to support that ongoing placement. I think courts have been really hesitant to dismiss DHS's legal custody, thinking the only way that family could get supportive services and that child gets services was if the child was in DHS's legal custody. Well, that's a significant interference with that familial relationship to have the child actually physically at home but legally in DHS's custody. When you're the legal custodian, you have significant rights and responsibilities about making decisions for the child. If the child's at home, I think the thinking is the parent should be making those decisions. So the intent of this bill was to try and get DHS backed out of those cases as appropriate. Okay? Questions?
Question. Talk to an attorney if we perceive that to be an issue with the court. If we want, the agency wants to dismiss, but we know the court may not feel like it's the right time.
The question is whether the DHS folks should talk to an attorney about cases in which they feel that the legal custody should be dismissed, but the court doesn't think that that's appropriate. Yes, or the DA, child's attorney. Usually the parents' attorneys would be supportive of that. They're not usually saying, no, keep legal custody. If it's an issue where there is a dispute about whether DHS's legal custody should be terminated, then that would be an appropriate case to consult with an attorney on to talk about that. But I think it is important that DHS set a realistic timeline for dismissal. It's not helpful if the child goes home today and the timeline is dismissal next week because it's, for whatever reason. But that kind of phasing out of DHS's responsibility. Is there another question? Did I see a hand?
Yeah, the state model allows us to return children home within home safety plan. In other words, we're still providing an authority to supervision in that home, monitoring and so forth. Would that same 6 months time limit apply to those children as well?
Ted's asking a question about the Oregon safety model allowing children to go home with an in-home safety plan and DHS providing services, and whether or not this 6-month reporting requirement would apply to those cases too. If DHS has legal custody, it applies. If legal custody has been returned to the parent, or if DHS never had legal custody of the child, then this would not apply. But it would seem you can provide services to those kids in their own home, even though DHS never had legal custody. Am I accurate on that one?
The difference is between safety services and change services like counseling and so forth. So those safety services would be more mandatory than saying we still want people to work on their case plan, complete those services and so forth. And that makes a lot of sense for those to be able to continue to run because people are engaged and so forth. Both of those safety services, that's a higher level of control that the agency feels like they need. But we want the ability to be able to have children with their parents, not in placement with all these strangers and moving from school to school, but they are with a safety plan in place. So what I'm just curious is if we need to think about that in terms of those return home plans, whether we've just got a 6-month window to be able to do that.
You don't have just a 6-month window. What it is you have to report every 6 months. And you have to identify a timetable for termination of DHS's custody and a list of the services. It's not that it's the outside is 6 months and then you're out. No, it could be a year and a half. But in that case, you'd have to submit 3 different reports at every 6-month interval. So no, you don't have just that 6-month window of responsibility or opportunity.
So do you anticipate that we'd be asking the court to set up the hearings on those at-home cases so that they coincide with the 6-month time period?
Well, the court the responsibility is on the court. Now, how you want to work that out locally in terms of that process, I think, is a discussion that the local managers here need to have with their local judicial folks. Does that mean in the report you need to have something at the top highlighted that says we need a hearing by this date? This is the 6-month report, you need a hearing? Or is there some process within the court system that will automatically identify it? I think those cases are going to have to be highlighted. I think it would be easy for courts to miss that. So it would seem to me that, like, as I said, the local management folks here from DHS should work with the court so that those cases don't get missed, and how does that happen? I don't think it requires a motion to schedule a hearing, because what the statute says is that upon receipt of the report, the court has to have a hearing. So I don't think DHS has to independently move for the scheduling of a hearing, but somehow highlighting that, I think, would be a good idea.
The ones that are within 6 months aren't going to be so difficult. We're likely going to have a review or permanency set anyway, but the ones that have to be done within 30 days, DHS really needs to highlight those for us, or else I won't know. And it may be very difficult to get it on my docket every day.
Yeah.
It may require me to set it at lunch or something, which is not unheard of.
Well, and the other thing is, you know, if you're going to have a hearing, like right before the child goes home, one thing might be to look forward and say, okay, we're going to need another hearing in 6 months. Let's get that on the calendar. And if you're back in 6 months, you can say, oh, we're going to need another hearing in 6 months. If that child, you know, unless the court dismisses legal custody, that hearing's going to have to keep happening every 6 months. So that's another way to think about making sure that these cases don't get missed. But I do think it's a local discussion about how are we going to make sure that that happens. Okay.
With all these cases being reviewed in court every 6 months, how does that impact the CRB?
Actually, there is a comment about that. All the reports in these cases have to go to the court and not to the CRB, and this is a judicial hearing, not a CRB. And maybe I don't want to show how ignorant I am, but aren't CRBs doing hearings only on substitute care cases?
Yes.
These kids are not in substitute care anymore.
Right.
They're at home.
Right. My question was more that permanency hearings happening every 6 months.
Mm-hmm. Like on the other permanency hearings that are happening? Well, a permanency hearing or a hearing can substitute for a CRB review if at the hearing the court has gone through all of the findings that the CRB would normally make.
Right.
Okay. So it may cut down on CRB.
Well,
it
if
may.
you're in court every 6 months,
Yeah,
it should.
It should.
That's why we want to be in court every 6 months.
Let me just talk very quickly about some money. There's been a number of questions here today about, gee, should we call our attorney? And the good news is you are going to have some more attorneys here in Multnomah County in the next six months or so. In the interim, the Attorney General, working with DHS, DAs, legislators, judges, the Judicial Department, CASA, CRB, held meetings and developed a policy package, a POP, not a PIP, to ask for a POP, not a PIP, to ask for more money from the legislature to fund some additional legal services for DHS. There are two facets of that request. One is funding for AG services. The other is funding for DAs. The Attorney General's office and this is a pretty big deal for the legislature to give us $5 million, I think is what it was. We got 10 additional attorney positions. In Portland, we will add 4 more positions for a total of 10. Salem will add 1 for a total of 4. Eugene, we will add 2 for a total of 5, and we're opening a new Medford office to cover Jackson, Josephine, Klamath, and Lake. And the focus of these additional attorney positions will be to review every case that DHS has where a child has been in substitute care for 4 months and then again at 10 months. We're doing 3 and 9, 4 and 10, 5 and 11, somewhere around there. So we'll do an initial review of the case and then a review of the case later on. First review will happen probably after jurisdiction is established, but before the first CRB. The second review will happen hopefully before the first permanency hearing if it's out that far. And we will have a checklist of all the issues that we want to talk about. We are, I think, moving forward with a pilot project in one county in the next several weeks to see how this works. We got the first print of cases. If a child has been in care for, let's say, 4 months and siblings have been in care for 9, 18 months, they may have come in at different points. We're going to review the entire case, not just the one child. We're going to review the whole family. And we're going to be looking at and talking to workers about those kinds of things that seem to plague DHS cases throughout the life of a case. Missing fathers, unresolved ICWA issues. We've got, relative diligent efforts to place with relatives, diligent efforts to place with siblings now on our list. So we have a whole list of things we're going to want to talk about. We are trying to develop a process so that it does not create significant additional work for workers. Attorneys are going to be filling out forms. We're going to use computerized prints from DHS so you don't have to recreate information. And we're figuring it's going to take us 20 to 30 minutes to do a review, and we're hoping to piggyback on to some of the consultations that you all are already having. The 90-day staffing, is it safety staffing? Is that what it is, the 90-day? That's really not a 90-day. It's more like everybody's looking at me blankly. So we're trying to piggyback on to some other things so you don't have yet another staffing to go to. We'll continue to do the consultation and litigation services on those criteria cases where there's something that has run amok or we've got some controversy. So those are going to continue. The second part of this is the DA package. We got $2 million to allocate to district attorneys' offices throughout the state to try and sweeten the pot so they will continue to do, or actually do more work pre-disposition, adjudication and disposition. It's not intended to replace the money that DA's offices are already allocating for that, but it is to encourage them to continue that and add more. And we have an intergovernmental agreement that we're working on that will outline what we are asking district attorneys' offices to do in exchange for the money. The allocation will be based on the number of children in a particular county, somehow combined with the number of children in poverty in a county. So if you have two similarly situated counties, one has a very high number of children living in poverty while the other county has a very low child in poverty level, the county with the higher poverty level will get more money. That's just to recognize that children who live in poverty come to the attention more often of the Child Welfare Agency than other children. Not that poverty is directly connected with abuse or neglect. So we'll be making those allocations after intergovernmental agreements are signed. And as I said, the intent is to try and encourage and support district attorneys' offices to do more work in the, shelter, hearing, pretrial conference, jurisdiction, and disposition phase, that they will attend all the hearings. They'll work closely with DHS on preparing the case, drafting petitions, getting witnesses ready, and moving forward. I know that's something that you already have very good support in this county, but this county is not the way it is everywhere. Any questions about that? No. Okay.